HFW, HKA, Herbert Smith Freehills, and Mac Consultant. Our silver sponsors, Chong and King Ho, Sarawak Energy, Shern Delamore and Co., Varg Art Chambers, and Bhaskaran. Last but not least, our bronze sponsors, Cecil Abraham and Partners, Changarut International Consultancy, GS Held, WCW Consulting, Ho Partnership, and Hanscom Intercontinental. We would also like to take this opportunity to express our utmost gratitude to the supporting organizations for our Asia ADR Week 2022. Beijing International Arbitration Center, Badan Arbitrasi Nasional Indonesia, Bani Arbitration Center, Bangladesh International Arbitration Center, China International Economic and Trade Arbitration Commission, the International Court of Arbitration at International Chamber of Commerce, Korean Commercial Arbitration Board International, the Malaysian Institute of Arbitrators, Hong Kong International Arbitration Center, Opus 2, UK Adjudicators, Chartered Institute of Arbitrators, Malaysia Branch, the Japan Commercial Arbitration Association, Philippine Dispute Resolution Center, Singapore International Arbitration Center, and Thailand Arbitration Center.
Mengumumkan keberangkatan Duli Yang Maha Mulia Paduka Seri Sultan Perak Darul Rizwan, Sultan Nazrin Muizzuddin Shah, Ibni Almarhum Sultan Azlan Muhibbuddin Shah Al-Mafurlah, dan diiringi dengan div-div kenamaan yang lain.
Negaraku,
Assalamualaikum warahmatullahi wabarakatuh dan salam sejahtera. Ampun tuanku, beribu-ribu ampun. Sembah patih mohon diampun. Menghadap Duli Yang Maha Mulia Paduka Seri Sultan Perak Darul Rizwan, Sultan Nazrin Muizzuddin Shah, Ibni Almarhum Sultan Azlan Muhibbuddin Shah Al-Mahfurullah. Ampun tuanku, patih memohon perkenan Duli Yang Maha Mulia tuanku untuk patih memulakan majlis. Patih dengan penuh hormat dan takzimnya mewakili Pusat Timbangtara Antarabangsa Asia merafak sembah dan menjunjung kasih di atas limpah perkenan Duli Yang Maha Mulia tuanku sudi mencemar Duli berangkat bagi menyempurnakan Majlis Pelancaran Minggu ADR Asia 2022. Sesungguhnya, keberangkatan Duli Yang Maha Mulia tuanku amat dinanti-nantikan yang sudah pasti menambahkan lagi seri majlis ini. Sokongan pada Duli Yang Maha Mulia tuanku telah memberikan suntikan semangat dan menyemarakkan lagi keazaman kami untuk meningkatkan usaha ke arah mematabatkan penyelesaian pertikaian alternatif. Ampun tuanku, patih sekalian menjunjung kasih. Bagi mohon keberkatan, majlis dengan segala hormat dan sukacitanya mempersilakan Imam Masjid Negara, Ustaz Khairul Ashraf bin Ahmad bagi memimpin bacaan doa.
Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin wal 'aqibatu lil muttaqin wassalatu wassalamu ala sayyidina Muhammadin wa ala alihi wa ashabihi ajma'in. Segala puji bagi Allah, Tuhan pentadbir seluruh alam. Selawat dan salam ke atas junjungan Nabi Muhammad sallallahu alaihi wasallam, ke atas keluarga dan sahabat baginda. Ya Allah, ya Tuhan, di hari yang barakah ini kami zahirkan rasa syukur yang tidak terhingga atas segala anugerah-Mu kepada kami seluruhnya. Lantaran itu, ya Allah, jadikanlah kami semua sebagai hamba-Mu yang beriman, bertakwa, berilmu, berakhlak mulia, sejahtera di dunia dan di akhirat. Ya Allah, ya Tuhan kami, bersempena Majlis Pelancaran Minggu ADR Asia 2022, Anjuran Asian International Arbitration Center AIAC yang akan disempurnakan oleh Duli Yang Maha Mulia Paduka Seri Sultan Perak Darul Rizwan, Sultan Nazrin Muizzuddin Shah, Ibni Almarhum Sultan Azlan Muhibbuddin Shah Al-Maghfurlah. Pada pagi yang cukup bertuah ini, kami memohon keampunan atas segala dosa kami, dosa kedua ipar kami dan seluruh kaum muslimin serta muslimat sama ada yang masih hidup atau yang telah kembali kepada-Mu, ya Allah. Allahumma ya basit, ya hafiz, ya raqib. Kami jua memohon restu dan rahmat-Mu bersempena majlis ini. Semoga Engkau, ya Allah, memberi hidayah dan petunjuk kepada hati-hati kami. Engkau memperkukuhkan perpaduan di kalangan kami untuk menjadikan aspirasi keluarga Malaysia menjadi realiti. Ya Allah, Engkaulah yang menjamin rezeki yang dikurniakan kepada kami. Maka Engkau berilah kekuatan serta semangat yang tinggi kepada kami. Dorongkanlah kami ke arah melaksanakan kebaikan dan amal soleh, serta kami mohon dipanjangkan usia dan diliputi dengan nikmat kesihatan, khususnya kepada seluruh kepimpinan negara kami yang tercinta ini. Allahumma ya Muhaimin, ya Aziz, ya Jabbar, ya Mutakabbir. Ya Allah, peliharakanlah negara kami Malaysia dan seluruh negara Islam yang lain dari sebarang huru-hara, wabak, bala bencana dan ancaman musuh yang ingin menggugat keselamatan, kesejahteraan, keamanan dan kemakmuran. Ya Allah, anugerahkanlah keberkatan kepada negara yang kami kasih ini. Peliharakanlah seluruh rakyat agar dapat menjalani kehidupan yang sejahtera sentosa. Martabatkanlah agama kami agar terus terpelihara dan maju jaya di bawah pemerintahan pemimpin-pemimpin kami. Allahumma ja'al jam'ana hadza jam'an marhuma wa tafarruqana min ba'di farqan ma'suma wa la taj'al Allahumma fina wa la ma'na wa la man yatba'una syaqiyan wa la matrudan wa la mahruma. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار وصلى الله على محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين.
Ampun Tuanku, beribu-ribu ampun. Sembah Patik mohon diampun. Patik memohon izin dan perkenan Duli Yang Maha Mulia Tuanku untuk Patik turut mengalu-alukan dif-dif kenamaan yang lain serta meneruskan majlis ini dalam bahasa Inggeris. Ampun Tuanku. The Right Honourable Tun Tengku Maimun binti Tuan Mat, Chief Justice of Malaysia, The Right Honourable Tun Datuk Seri Zaki Tun Azmi, Chief Justice of the Dubai International Financial Centre Courts and former Chief Justice of Malaysia, Yang Teramat Mulia Raja Datuk Seri Elina binti Almarhum Sultan Azlan Muhibbuddin Shah Al-Maghfurullah, Yang Amat Berbahagia Orang Kaya Bendahara Seri Maharaja General Datuk Seri Diraja Tan Sri Datuk Muhammad Zahidi bin Haji Zainuddin, Yang Berbahagia Datuk Dr. Praset Sandosham Ibrahim, Deputy Director of the Asian International Arbitration Centre, distinguished guests, ladies and gentlemen. A very good morning and warm welcome to the Asian International Arbitration Centre, or more commonly known as the AIAC. My name is Sabrina Sharin, and together with me,
I am Sanjeev Sharma.
And we will be your masters of ceremony for the next 3 days. Our theme for this year's Asia ADR Week is Compasses, the Odyssean course to modern ADR. On behalf of the AIAC, we are truly pleased and honored to be able to welcome and host all of you in this momentous event today.
To begin the event, we would like to call upon the Director of the AIAC, Yang Berbahagia, Tan Sri Datuk Suryadi bin Halim Omar on stage to deliver his opening remarks. Please welcome Yang Berbahagia Tan Sri.
Bismillahirrahmanirrahim. Menghadap ke bawah Duli Yang Maha Mulia Paduka Seri Sultan Perak Darul Rizwan Sultan Nazrin Muizzuddin Shah Ibni Almarhum Sultan Azlan Muhibbuddin Shah Al-Maghfurullah. Ampun Tuanku, beribu-ribu ampun, sembah Patik mohon diampun. Patik merafak sembah dan menjunjung setinggi-tinggi kasih atas limpah perkenan Duli Yang Maha Mulia Tuanku mencemar Duli berangkat ke majlis yang mulia ini. Sesungguhnya, keberangkatan Duli Yang Maha Mulia Tuanku telah menyerikan lagi majlis pada hari ini. Ampun Tuanku, Patik merafak sembah dan memohon ampuni limpah perkenan Duli Yang Maha Mulia Tuanku untuk Patik turut mengalu-alukan dif-dif kenamaan yang lain serta meneruskan sembah ucapan Patik dalam bahasa Inggeris. Ampun Tuanku. A very good morning I bid to everyone and a very warm welcome to the Asian International Arbitration Centre, AIAC. I would like to begin by expressing my sincerest appreciation to the Right Honourable Tun Tengku Maimun binti Tuan Mat, Chief Justice of Malaysia, the Right Honourable Tun Datuk Seri Zaki Tun Azmi, Chief Justice of the Dubai International Financial Centre Courts and former Chief Justice of Malaysia. Yang Teramat Mulia Raja Datuk Seri Elina binti Almarhum Sultan Azlan Muhibbuddin Shah Al-Maghfurullah. Yang Amat Berbahagia Orang Kaya Bendahara Seri Maharaja General Datuk Seri Diraja Tan Sri Muhammad Zahidi bin Haji Zainuddin, and all of you here, distinguished speakers, ladies and gentlemen. Thank you for taking the time to join us in commemorating this momentous event. We are gathered here today to celebrate the launch of the AIC's Asia ADR Week 2022. Last year, we were restricted in our celebration of this event with the COVID-19 pandemic necessitating the conduct of the ADR Week to be held within the walls of our home virtually. However, today, I'm extremely pleased and honored to be able to be here with you physically to deliver my opening remarks. As you all know, Alternative Dispute Resolution, or ADR, refers to a mechanism for conflict resolution without going through litigation or courts. It is, in every sense of the word, a mechanism that serves as an alternative. Over the years, the success of the ADR vehicle has helped reduce personal and public cost of disputants, whilst also preserving pre-existing business relations and goodwill. The practice of ADR also avoids placing unnecessary burden on the court system, as evident in our mandate to serve alongside and to complement the civil service system. The specialist and confidential nature of ADR proceedings is also an attractive, or rather a favorable incentive which typically prompts parties and stakeholders to adopt ADR as their preferred mode of dispute settlement. The AIC was established in 1978 pursuant to a host country agreement between the government of Malaysia and the Asian African Legal Consultative Organization, or otherwise known as ALCO. 40-odd years later, and fast forward to the present day, I'm proud to say that the AIAC has made a remarkable strides in keeping to its mandate in serving as a conducive, relevant, and cost-saving institution for the administration of domestic and international commercial disputes through various means of ADR. In doing so, the AIAC has developed its own set of procedural rules to cater for the growing demand of ADR, such as our AIAC Arbitration Rules 2021, AIAC Islamic or I-Arbitration Rules 2021, AIAC Adjudication Rules and Procedure, AIAC Mediation Rules 2018, and AIAC Guide to Domain Name Dispute Resolution. As part of its endeavor to assist and provide guidance to its pool of neutrals, such as arbitrators, adjudicators, and mediators appointed by the AIAC, as well as to supplement the practice area of ADR, the AIAC has embarked on various competency-related efforts, such as its publication of recommended good practices, circulars, and journals, amongst others. In extension to ADR, the AIAC has also been committed in spearheading the utilization of dispute avoidance instruments. This includes the publication of our standard form of contracts, or normally we call it SFC, that is a suite of standard form contracts that were introduced to fill the gaps and vacuums of existing standard form building contracts in governing relationships, rights and duties of parties to a building construction project. Echoing the aspirations of the AIC, the Asia ADR Week serves as our annual flagship event in promoting the use of the modern ADR mechanisms in resolving disputes between parties. The Asia ADR Week was first inaugurated in 2018 with the theme, Discover the Difference, the Asian Experience, followed by the Kinsukuroi Perspective, the Asian ADR Revolution in 2019. With the advent of the COVID-19 pandemic as well as nationwide imposed movement control orders, the AIAC was constrained from organizing the third edition of the ADR Week in the year 2020. the ADR week was given a renewed breath of fresh air in 2021 with our first ever fully virtual ADR week with the theme ADR in Kaleidoscope Beyond What Meets the Eye. This year, we are pleased to showcase our transition to the new norm with our first hybrid Asia ADR week, aptly themed Compasses the Odyssean Course to Modern ADR. This year's theme is a poignant reflection of the storms that the ADR community have weathered for the past 2 years and the pivotal role of the AIAC as a compass in guiding practitioners, stakeholders, and businesses in finding their way to resolve their conflicts in a swift and efficient manner. This year's theme is derived from the widely known Homer's Odyssey, an ancient Greek poem dedicated to Odysseus' journey home, which lasted for 10 years after the end of the Trojan War. Throughout his journey home, Odysseus triumphed over many dangers and perils by relying on his resilience and determination, which ultimately lead him back to his rightful seat of his kingdom. The compass, being a marvelous magnet as we know it, is one of the four great inventions alongside paper, gunpowder, and printing. The compass has been a device of great counsel for travelers, seafarers, and explorers in steering them through their voyages as early as 206 BC. Though the AIAC may not date its inception back to the classical era, we certainly resonate with the spirit of reliability, guidance, and progress in what we do in this institution. Thus, the amalgamation of Homer's epic poem and of the compass canvassed a beautiful illustration of the role of the AIAC, being an institution of guidance, assisting parties in navigating through the turbulence of modern ADR by fostering awareness as well as administering and guiding stakeholders in the practice of modern ADR. Your Royal Highness and distinguished guests, the growing traction of ADR over the years has invariably seen the emergence of contemporary issues, with our industry often actively engaging in domestic and international discourse for the purposes of ensuring continuity of jurisprudential development. In recent years, we have witnessed how the escalation of armed conflicts play a dangerous role in destabilizing local, international, and transnational economies, and how it affects international dispute resolution. As such, the first session of the Asia ADR Week program will focus on why it is imperative for us as members of the ADR industry to consider prevalent and current global issues that extend beyond the norms, and why special attention must now be given to devise effective and relevant solutions towards preserving efficient administration and conduct of ADR proceedings, not just in the face of commercial conflict, but also political conflict. Being mindful that disputes are no longer confined to the physical world, we then move on to domain names dispute. The fight for one's internet domain remains as fierce as kinetic battles within the realm of cyberspace. In the face of the .com frontier, domain name disputes, which often revolve around the reinforcement and assertion of one's domain name, are gaining significant momentum as businesses and trademark owners are becoming more watchful on their online presence. With that being said, the potential of domain name dispute resolution remains imperative for us to explore in this year's edition of the Asia ADR Week. With the advancement of technology, it is pertinent that we understand the application and integration of modern technology in the field of ADR, modern investment banking, such as the use of cryptocurrencies and the development of the digital asset industry, have been growing at a rapid rate, and the relevancy of effective dispute resolution mechanisms are more apparent now than ever. Thus, the arbitrability of disputes arising from modern technology should be carefully considered. One of the most fascinating technological developments is the introduction of artificial intelligence. The development of artificial intelligence has amazed me over the years. Back in the days of yore, music would require the use of an old record player. Evidently, this is no longer the case with technology like online platforms such as Spotify, providing easy and one-stop access to music that cuts across continents and generational difference. Whilst the saying used to be, everything is at your fingertips, the advancement of technology at such a rapid pace has made possible systems to work with voice recognition. Therefore, today, it is not just fingers alone, but voice and audio assistance too. The incorporation of voice recognition technology in legal services may allow for a more efficient legal proceeding. The influence of technology in ADR in recent years has prompted the AIAC to partake in numerous innovations to cater the evolving needs of the ADR users. To that end, this year's Asia ADR Week will also feature a session on how modern technology can be integrated into ADR processes in various aspects such as investment banking, blockchain-related disputes, and artificial intelligence. The emergence of fast fashion platforms has taken the world by storm due to its accessibility with fashion houses, big or small, shifting their marketing and operation strategies to the internet. However, fast fashion is not without its criticism, with a consumption rate of over 80 billion pieces of clothing a year. Issues and disputes on design and intellectual property exploitations by fast fashion houses in order to meet the ever-increasing consumption rate is a question that demands attention in a world where environmental and social governance policies are taking center stage. Thus, it is important for us to examine the intricacies of the fast fashion industry and how stakeholders may utilize ADR as an efficient and cost-saving mechanism to safeguard their businesses from exploitative practice and resolve fashion disputes while preserving the goodwill of their reputation. Your Royal Highness and distinguished guests, an esteemed panel of speakers will kickstart the second day of this year's Asia ADR Week to discuss and explore the potential reforms needed to the Malaysian Arbitration Act 2005. This session aims to promote discourse and will serve to complement ongoing efforts to keep our legislative framework continually reflective of modern arbitral practices. Participants will be given insight to consider the need for further modernization of the statutory framework and the extent as well as scope of such. The views that will be exchanged in this session will prove to be valuable for our collective chartering of Malaysia's ADR scene and how our growth will serve to compare amongst other leading arbitration jurisdictions. As a call to arms of sorts, I invite all of you to actively participate in this session and share your thoughts on how we can steer the future of Malaysian ADR onto a new terrain. The recent passing of the bill in Singapore, permitting parties to enter into conditional funding agreements as an alternative to traditional fee arrangements, is one such instance of our need to embrace new frontiers. Conditional funding agreements, which enables part or all of a lawyer's fees and costs to be conditioned on the outcome of the dispute, is a topical issue which builds upon discussions that we have had in the past on third-party funding. Malaysia has much to consider insofar as how tenable this concept will be, or other concepts will be, and how, where suitable, they are to be given a legislative enforceability. To this end, there is much for us to learn from and to take away from the views of our esteemed speakers from Hong Kong, Singapore, the United Kingdom, and Australia on their respective jurisdictions' framework of conditional funding agreement and other financing arrangements of disputes such as third-party funding. With 3 meticulously curated breakout sessions on issues commonly faced in arbitrations to follow, our participants are sure to be in the thick of the week's thought-provoking discourse. The first breakout session will consider the beast of parallel proceedings, often seen in investor-state disputes. We consider the predicament of having 2 inconsistent awards, which arise from the curious scenario of parallel proceedings, which in turn result in uncertainty at the enforcement stage. The second breakout session scrutinizes the duality between summary judgment applications in civil litigation, or more commonly known to our practitioners here as Order 14 applications. And on the other hand, summary determination proceedings, being the newly incorporated summary procedure of the AIAC Arbitration Rules 2021. I should probably at this stage add that since its introduction just over a year ago in August 2021, the AIAC has been in a receipt of 4 summary determination applications in active arbitrations. This, to us, has been a monumental achievement and serves as validation of our efforts and the ADR community's positive reception of the improvements that we have made through the new features introduced in the AIAC Arbitration Rules 2021 towards ensuring expediency and efficiency or effectiveness in arbitration proceedings. In considering the similarities and differences of summary judgment and summary determination applications, my hope is for participants in this session to have a greater appreciation for its utility. The third and final breakout session delves into the perceived practice of arbitral tribunals of compromising when making decisions, or commonly referred to as, quote, baby splitting, unquote. The question that begs consideration is whether compromises merely serve as a positive and beneficial extension of features such as party autonomy and flexibility. Is it designed to realign the relationship of parties and set them back on the track? I anticipate diverging opinions to emerge throughout the discussion. But I'm certain that participants will definitely leave from the discussion with more to think about and reflect in terms of their own personal conduct of arbitrations. We then conclude the second day of our Asia ADR week with an interesting discussion on the role, features, rationality, sustainability, and capability of arbitration in bridging the gap between business and human rights, environmental, social and corporate governance, and employment disputes. These areas have gained popularity in recent years, but the arbitrability of disputes under these categories somehow remain aspirational, which leaves plenty of room with healthy discourse. To that end, it will be interesting to see what trends we can assimilate into our practices of ADR, and to what extent they can form realistic and achievable goals for modern ADR. On that note, I'm sure many of you are just as excited as I am to engage in multiple opportunities to network with one another. It has, after all, been some 2 years of this coming to a halt. In addition to, or rather coming to a halt, in addition to the various networking breaks that we have as part of this week-long event, this year, the AIAC will once again be hosting an evening reception at the conclusion of our Day 2 program. I would like to take this opportunity to invite all of our participants, speakers, moderators, and distinguished guests to join us for an evening to reconnect with our old friends, meet new faces, and foster friendships in a renewed spirit of collegiality. I, for one, am looking forward to meeting all of you and have a little bit of fun for myself, of course. We sail back to the final day of our Asia ADR week, featuring our SIPA Conference Day, a day that specially focuses on the Construction Industry Payment and Adjudication Act, or SIPA 2012, as we more colloquially refer to it. The first session in the SIPA Conference Day will feature 3 exciting rapid-fire debates that will delve into the legal and technical aspects of the provisions of the SIPA. Following the debates, a discussion on the urgent need for reforms on SIPA is to take place, sounding a clarion for the active engagement of all stakeholders towards revisiting the SIPA legislative framework to shape a better future for the construction adjudication industry. The final session of the SIPA Conference Day will assess the repercussions of the increase in the prices of goods and services to the construction industry. I am hopeful that the vessel that this year's ADR week is poised to bring us through the waves and storms with a wholesome understanding in addressing contemporary issues whilst appreciating the strides that our industry has made over the last few decades. Nearly there. I encourage participants to engage with our globally represented and diverse panel of speakers and to stay open, inquisitive, and take this opportunity to not just widen their intellectual horizons, but to also foster meaningful and long-lasting friendships throughout the Asia ADR Week. The AIAC is truly grateful to those who have provided us with the support in one way or another. On behalf of the AIC, I would also like to take a moment to provide my sincere appreciation to all our sponsors for making this grand event possible. This is truly an event created by the ADR community for the ADR community. To end my speech, I wish to express my utmost appreciation to Your Royal Highness Sultan Nazrin Muizzuddin Shah Ibni Almarhum Sultan Azlan Muhibbuddin Shah Al-Maghfurullah Sultan of Perak, and all attendees for your time and interest towards our ADR week. I therefore welcome everyone on board to the AIAC's Asia ADR Week 2022, compasses the audition course to modern ADR. Ampun tuanku, demikianlah ucapan sembah ucapan Patik. Patik sekali lagi dengan penuh hormat dan takzimnya merafak sembah menjunjung setinggi-tinggi kasih di atas limpah perkenan Duli Yang Maha Mulia tuanku bercemar duli berangkat ke majlis pada pagi ini. Patik mendoakan agar Allah Subhanahu wa Ta'ala sentiasa melindungi serta terus memberkati pemerintahan Duli Yang Maha Mulia tuanku. Ampun tuanku, beribu-ribu ampun, sembah Patik mohon diampun. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Tan Sri, for your opening remarks. Today's event is indeed a reflection of AIAC's unwavering commitment in acting as a compass in guiding, facilitating, as well as promoting the administration of ADR in an ever-expanding ocean of international commerce. With that said, your presence here today is certainly a testament of your warm support and collective spirit to AIAC and the ADR industry in charting a new course for the future advancement of ADR. Your Royal Highness, distinguished guests, ladies and gentlemen, without further ado, we would like to call upon the Right Honourable Tun Tengku Maimun binti Tuan Mat, the Chief Justice of Malaysia, to deliver her special address on stage.
Menghadap ke bawah Duli Yang Maha Mulia Paduka Seri Sultan Perak Darul Rizwan, Sultan Nazrin Muizzuddin Shah Ibni Almarhum Sultan Azlan Muhibbuddin Shah Al-Maghfurullah. Ampun tuanku beribu-ribu ampun, sembah patik mohon diampun. Patik memohon limpah perkenan Duli Yang Maha Mulia tuanku untuk patik meneruskan ucapan kepada para hadirin dalam bahasa Inggeris. Ampun tuanku. Yang amat berbahagia Tun Zaki bin Tun Azmi, Chief Justice of the Dubai International Financial Court and former Chief Justice of Malaysia. Yang teramat mulia Raja Elena, Datuk Seri Raja Elena binti Almarhum Sultan Azlan Muhibbuddin Shah Al-Maghfurullah. Yang amat berbahagia Datuk Seri Diraja Tan Sri Dr. Muhammad Zahidi bin Haji Zainuddin, Orang Kaya Bendahara Seri Maharaja General. My brother and sister judges of the Superior Courts of Malaysia. Yang berbahagia Tan Sri Datuk Suryadi bin Halim Umar, Director of the Asian International Arbitration Centre. Datuk Dr. Prasad Sandosham Abraham, Deputy Director of the Asian International Arbitration Centre. Distinguished guests, participants, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh and a very good morning. I would like to begin by expressing my appreciation to the organizers for the honor of delivering this special address to mark the launch of the Asian International Arbitration Centre's AIAC highlight events of the year, the Asia ADR Week 2022. This is in contrast to the last year's setting to which I was honored to deliver the opening remarks virtually. It therefore gives me great pleasure to be here physically at Bangunan Sulaiman. To those attending online, I would also like to extend my greetings. This year's AIAC's Asia ADR Week 2022 themed compasses the Odyssean course to modern ADR, reflects one of Homer's literary works, Odyssey, and the Latin word compassus, which entails the English word of compass. The amalgamation of these two creations for this year's Asia ADR Week brings about the resonating spirit of the ADR industry as it endeavors to bring together the ADR community from across the globe in showcasing its developments and at the same time addressing new contemporary challenges. For the upcoming days, the Asia ADR Week 2022 will be packed with exciting and dynamic programs which include discussions on contemporary challenges facing the ADR landscape both internationally and domestically. The programs will range from the effects of armed conflict towards international arbitrations, the rise of blockchain-related disputes, the integration of artificial intelligence AI, to noteworthy discussions and debates on the Malaysian Arbitration Act 2005 and the Construction Industry Payment and Adjudication Act 2012, or better known as SIPA 2012. These discussions are imperative in ensuring the relevancy of ADR practices, the steady growth of which is supported by the Malaysian Judiciary, arbitral institutions, stakeholders, and disputants who seek justice through the means of ADR. Ladies and gentlemen, the Judiciary recognizes the crucial role of arbitration and other alternative dispute resolution mechanisms. ADR such as mediation, negotiation, and arbitration are all avenues for parties to settle their disputes without going through the long and tedious process of litigation. That said, there have been differing opinions as to how the relationship between the courts and arbitral institutions should be perceived. It can be argued that those avenues of dispute resolution belong to two competing realms, distinct from one another. However, I am inclined to state that both these avenues of dispute resolution actually complement each other in the pursuit of justice. Strongly influenced by the general principle of minimal intervention, our judiciary takes pride in adopting a pro-arbitration stance, given our extensive and evolving legislative framework on the subject. This is reaffirmed by recent court decisions in Pada Gurtaj Singh against others and Axiata Group Berhad, Tindak Murni Sdn Bhd and Juang Setia Sdn Bhd, and K&M Process Systems Sdn Bhd against Lukoil Uzbekistan Operating Company. In the recent federal court decision of Masenang Sdn Bhd and Sabah Nilam Enterprise Sdn Bhd, the Apex Court adopted a practical approach where it unanimously held that the court at the seat of the domestic arbitration enjoys exclusive jurisdiction to exercise supervisory and regulatory powers over the arbitration proceedings. The ascertainment of the seat of arbitration in any arbitral proceeding is therefore essential and relevant in domestic arbitrations. Even Tuanku's late father, Almarhum Sultan Azlan Shah, delivered authoritative judgments in several landmark decisions dealing with important areas of arbitration law. For example, in the case of Alagapa Chatiar against Palanivel Pillay and others, Almarhum Sultan Azlan addressed the importance of arbitration, stating that persons who seek to stay court proceedings and remit the matter in dispute to arbitration must satisfy certain ingredients. In this regard, it is evident that Almarhum Sultan Azlan was acutely aware of the importance of arbitration as an alternative dispute resolution and took great care to formulate the applicable principles in his customary, clear, and lucid manner. In my view, the role of the judiciary in the context of the ADR based on the law that has developed is mostly supervisory. Affording parties greater autonomy in how they choose to resolve their disputes enables them to attain a remedy more speedily and effectively in the forum of their mutual choosing. Courts are only here to assist in upholding what the parties have agreed to in the first place. That is not to say that the courts are totally irrelevant. For one, as they continue to retain supervisory powers, their position as the final beacon of justice is preserved. Their limited role is to respect party autonomy. After all, parties cannot complain about the process if that is the process they had elected to apply. It cannot also be said that ADR, given its flexibility, is a zone of anarchy. Although ADR works at the pace elected by parties, their mechanisms are governed by a discernible process established by substantive law. I must also add that the judiciary, having a supervisory role and relegating its adjudicatory powers to ADR fora is not an affront to the rule of law. Neither is it an indication that the judiciary is no longer interested in the work. The bigger picture here is upholding the rule of law consonant with the fundamental right of access to justice. In this regard, as ADR tribunals remain answerable to the law and are not immune from judicial scrutiny where it is warranted, the rule of law and the role of an independent judiciary will still be maintained. The independence of the judiciary is a concept that is embossed in the very fabric of the justice system. Duli Yang Maha Mulia Tuanku Nazrin too has very recently spoken on this. To quote Duli Yang Maha Mulia Tuanku, there should not be any doubts and a judge must be free from any influence or pressure. Although Duli Yang Maha Mulia Tuanku's address was in relation to the Syariah courts, the considerations in relation to the Malaysian judiciary and even the ADR systems remain the same. Both systems should strive to provide reasoned decisions while deciding cases independently, fairly, and without fear or favor. In this regard, I can do no better than to humbly echo Duli Yang Maha Mulia Tuanku's sentiments. In this light, the significant role of the AIAC cannot be understated. As one of the leading arbitration institutions in the region, the AIAC, in its efforts to improve efficiency in conducting arbitration proceedings, launched the AIAC Arbitration Rules 2021 on 1st August 2021. The AIAC Arbitration Rules 2021 reflect contemporary standards and practices in domestic and international arbitration through the confluence of the Ancestral Arbitration Rules 2013 with the AIAC's own provisions. Further, AIAC has also launched the AIAC-I Arbitration Rules 2021, which aim to set the benchmark for international best practices and standards for Islamic arbitrations. The I Arbitration Rules 2021 features new provisions for the fast-track procedure, Sharia-guided third-party funding, and appointment of Sharia experts. The rules also revamp the provisions relating to notice of arbitration, response to the notice of arbitration, registration of arbitration, reference to Sharia counsel, powers of arbitral tribunal to award ta'wid and gharamah, and expenses of the arbitrator to enable the application of Sharia principles throughout the proceedings. The launch of these new arbitration rules, together with other initiatives by the AIAC, will definitely assist judges as well as ADR practitioners in conducting arbitration matters within the framework of the IAC fairly and expeditiously. The Judiciary is pleased to continue to collaborate with AIAC on several capacity building initiatives for the wider ADR community, whereby my learned colleagues have often served as guest speakers and lecturers in providing the court's perspective and jurisprudence behind the legal developments of contemporary ADR proceedings. One such example is the AIAC Arbitration in Practice Workshop Series, which is specifically designed to keep practitioners updated on the latest legal developments domestically and internationally. To conclude, alternative dispute resolution has become an increasingly dominant feature of the justice system, traversing the gap between commercial reality and law, making alternative dispute resolution a more appealing choice for parties entering into transactions and even those that are already in the midst of ongoing disputes. The Malaysian Judiciary will always support the growth of ADR, with the AIAC continuously promoting and facilitating ADR, and with the constant support from the other relevant dispute resolution bodies. I am confident that the future of ADR is safe. If I may draw an analogy befitting of today's theme, the AIAC and the Judiciary are mere parts of a compass in the pursuit of justice. We may be made out of different materials, but just like a compass, its needle will not rotate if the compass does not have a functioning baseline or scale. Only if both parts play a functioning role will it serve its purpose to be an effective tool, and as it is in our case, to navigate through the terrain of justice. With that, I wish you a fruitful Asia ADR Week 2022. Thank you. Ampun tuanku, sekianlah sembah ucapan patik. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Ampun tuanku.
Thank you to the Right Honourable Tun for your special address. It has been our utmost privilege to have you here at the opening ceremony. We now move on to the highlight of today's opening ceremony. That is the royal address by His Royal Highness Sultan Nazrin Muizzuddin Shah, Ibni Almarhum Sultan Azlan Muhibbuddin Shah Al-Makfurlah, the Sultan of Perak Darul Rizwan. We would like to call upon Yang Berbahagia Tan Sri Datuk Suryadi to entreat His Royal Highness on stage to deliver his royal address.
Bismillahirrahmanirrahim. A very good morning, ladies and gentlemen. The theme of this year's conference compasses the Odyssean course in modern ADR, immediately brings to my mind questions of future direction and the path to be charted. The Odyssean course refers to the Greek hero Odysseus, who tied himself to the mast of his ship as he passed the sirens to avoid the temptation that might cause him to steer his ship off course. Listening to the sirens and their alluring melody would have sent him on a path to destruction. It took Odysseus more than a decade to return home, steered by great feats of determination and intellect. The journey was an arduous one, but he was rewarded by the satisfaction of being reunited with his family. With that in mind, this year's Asia ADR Week is aptly themed. It encapsulates the spirit and meaning of guidance and the need to stay the course, however difficult, if we are to achieve our goals. I am delighted to be given the opportunity to address such a stellar panel of speakers and participants at this year's conference. I understand that this conference is now an established tradition of the AIAC. It has become a showcase of knowledge, content, diversity, and accessibility for the global ADR community, and as such, is already a highly anticipated event. Let me state at the outset that unlike most of you here this morning, I am not a legally trained person. But as a ruler, I hold the federal and state constitutions and the laws of the land close to my heart. I have a layperson's knowledge of the Arbitration Act 2005 and of the work of AIAC and other arbitral institutions. I am eager to learn more about the work of all arbitral institutions. The peaceful resolution of disputes is one of the hallmarks of a developed and civilized society. By providing a means of resolving disputes outside the courts, ADR lightens their burden. The mediation, arbitration, and conciliation efforts of the AIAC thus make an important contribution to justice and the rule of law in our country. AIAC provides a structured, interactive process whereby an impartial third party assists the disputing parties to resolve conflict using specialized communication and negotiation techniques. Though its role is not yet widely acknowledged, the AIAC is very much part of the legal pluralism of our land. Without seeking to undermine traditional judicial proceedings, let me reflect briefly on what many scholars say are the advantages of arbitration proceedings as compared to judicial ones. First, as it is confidential and private, arbitration enables businesses to keep their affairs away from public and media attention. Litigation, on the other hand, takes place in open court. Second, the arbitrator is selected by both parties based on their expertise, whereas a trial judge in court may be a generalist who is assigned without input from the parties. Third, in court proceedings, there is a winner and a loser. In arbitration, mediation, and conciliation proceedings, middle paths can be forged. Fourth, arbitration generally provides a speedier resolution than litigation. Due to the backlog of litigation cases, pre-trial discovery and the appeal process can be painfully slow. Arbitration is usually less time-consuming. Fifth, arbitration is considered to be more flexible than litigation, in part because the legal framework of litigation processes is extremely complex. Litigation must follow the laws of civil and criminal procedures and evidence. In arbitration, there is no strict procedural code, and the arbitrator and parties are said to have procedural flexibility. The diverse range of ADR mechanisms, from mediation to conciliation to arbitration and adjudication, as well as its hybrid forms, provides additional flexibility. Sixth, some forms of ADR, such as mediation, are less costly than court proceedings. However, there are conflicting opinions on this matter in relation to the costs of arbitration. Finally, arbitral awards rendered in Malaysia are enforceable in 168 contracting countries under the United Nations-backed New York Convention of 1958. As I see it, litigation, arbitration, mediation, and other forms of ADR can be thought of as being like rivers. They flow side by side, all of them heading towards the ultimate goal of a peaceful and amicable solution. But let us not forget the wise words of Joseph Greenbaum, who said, and I quote, "An ounce of mediation is worth a pound of arbitration and a ton of litigation," unquote. The various advantages of ADR have contributed to its increased use, and the AIAC has in turn benefited from this growth. As I understand it, the current expertise of the AIAC is focused on maritime arbitration, cross-border investment arbitration, construction arbitration, sports arbitration, as well as domain name dispute arbitration. In order to benefit from the growth in international arbitration and to ensure that our own expertise matches that of other leading arbitration institutions, the industry will require experts in other kinds of disputes. As a starting point, we can focus on disputes concerning energy and natural resources. The COVID-19 pandemic and the increasing effects of climate change have led many businesses to rethink how best to protect themselves against the adverse consequences of unforeseeable events. But even with greater awareness of the types of disputes that may arise in the context of unexpected occurrences, such as extreme weather, defining what constitutes unforeseeable is highly challenging. Moreover, what is reasonably foreseeable may vary across different jurisdictions. This greater degree of unpredictability is likely to generate disputes. Whatever the kind of unexpected event, the particular characteristics of the natural resources and energy sectors will need to be taken into consideration. The evolving markets in these sectors, with their complex contractual arrangements, international supply chains, and operations spanning a number of jurisdictions, are likely to be a rich source of the kind of disputes that are best suited to international arbitration. Another area of growing interest is that of banking and finance. Historically, financial institutions have preferred to resolve disputes in courts. Persuaded by a large body of judicial decisions that this route results in more predictable outcomes. However, arbitral institutions have been reporting growing activity in this sector. For the London Court of International Arbitration in 2021, for example, the financial services sector was the source of more international arbitrations than any other sector. So we need to be better prepared to attract the disputes that arise out of complex, multi-jurisdictional financial transactions. One welcome development in specialized financial arbitration is the Prime Finance Arbitration Rules, which came into force on the 1st of January this year. Prime stands for the Panel of Recognized International Market Experts in Finance. It is an independent, not-for-profit foundation which retains a large panel of specialist arbitrators in the sector. Its mission is to ensure that the requisite expertise is available to address any disputes that may arise in financial markets. The AIAC must ensure that it keeps well abreast of these and other relevant rules in this sector. Expertise is also needed in the field of technology, including in cutting-edge areas such as space exploration. In disputes related to emerging and developing technologies, expert decision makers are often the best placed to determine novel issues of fact and law. Through international arbitration, disputing parties can benefit from the appointment of such experts with specialist understanding of the industry context and the technical aspects of the technology in question. Again, the AIAC must develop sufficient expertise to be able to take advantage of expected growth in this area. We are likely to see an increase in disputes in many other sectors. They may arise as businesses seek to adapt to the removal of temporary statutory protections in a post-pandemic world, and as businesses try to recover and expand in the midst of geopolitical instability and a global economic downturn. International arbitration is perfectly poised to act as a forum to resolve such disputes. It is particularly suitable to settle disputes involving incorporeal and borderless technologies such as blockchain and artificial intelligence, as well as in many other areas. The New York Convention helps greatly by simplifying the process of obtaining an award for enforcement in foreign jurisdictions. Moving closer to home, it is good to see dispute resolution mechanisms evolving from the conventional mechanisms, in particular, conventional arbitration to Islamic arbitration. It is indeed commendable that the AIAC has promulgated its own arbitration rules. First published in 2012, this important innovation was recognized in a prestigious international award from the Global Arbitration Review. These rules were recently revised and updated in the arbitration rules of 2021. As a leading center for Islamic finance, Malaysia should continue to focus on this area of dispute resolution within the general framework of Islam. The AIAC would do well to gather a pool of experts in this area to become the preferred hub in Asia, specializing in Islamic finance arbitration, as well as in disputes within halal industries. However, two challenges should be highlighted in this respect. The first relates to the low uptake of Islamic arbitration. Despite Malaysia having a comprehensive and up-to-date legal framework for Islamic arbitration in place through the AIAC, arbitration of Islamic finance disputes is not a popular option. Rather, litigation is still preferred. One reason for this, according to the ICC Task Force on Financial Institutions and International Arbitration in their 2018 report, is that Islamic financial institutions are reluctant to have their disputes decided by arbitrators in accordance with Sharia because of the greater uncertainty of the outcome. A lack of awareness of the various products and services that deliver Islamic forms of arbitration could be another reason for the limited uptake. So increasing understanding of Islamic arbitration and of its benefits among stakeholders is another important task. Islamic arbitration provides a unique path to amicable dispute resolution for businesses in this space. By providing a confidential means of settling disputes and maintaining the mutual goodwill of the parties, it helps to promote more stable business relationships. A distinctive feature of Islamic arbitration is the need for an additional layer of consultation with either the Sharia counsel or a Sharia expert. According to Rule 29 of the Arbitration Rules 2021, the Sharia counsel has a maximum of 90 days to make its ruling. After this, the arbitrator may decide the issue on his own. This pre-arbitration tier increases the time taken to resolve any case. To address this issue, steps could be taken to train those with specialization in Sharia, fiqh, and mu'amalat as Islamic arbitrators. This would enable disputes to be resolved without the need to involve a Sharia counsel or expert. This would make Islamic arbitration more attractive and easier than litigation. To enable this, incentives and career paths must be formulated so that graduates of Sharia can pursue a career as Islamic arbitrators. In other words, talent and human resources should be developed in the field of Islamic arbitration. Measures can also be introduced in relation to conventional arbitration to ensure that we continue to build our capacity more broadly in all areas relevant to ADR. So schools, colleges, and universities could incorporate negotiation-based ADR as part of their curriculum. Training institutions can also be mobilized to share skills and help to develop effective ADR practitioners. The judiciary has and continues to play an important role in promoting Malaysia as an arbitration-friendly jurisdiction. In recent years, the judiciary has consistently taken a pro-arbitration stance. In numerous cases, the courts have upheld arbitration agreements despite minor flaws, supporting the choice of the parties to resolve their issues in this way, as well as refraining from interfering with the decisions of arbitral tribunals. The courts here have also passed a number of landmark arbitration-friendly judgments. Some key issues remain, however, especially with regard to questions of jurisdiction. Arbitration can, of course, only be applied in limited cases, as assigned by the law in Section 4 of the Arbitration Act. Many areas are excluded. Why this should be so is a matter for discussion. Perhaps, in more and more civil and commercial matters, ADR should precede court processes. As U.S. Justice Sandra Day O'Connor once said, and I quote, "The courts of this country should not be the places where resolution of disputes begins. They should be the places where the disputes end after alternative methods of resolving disputes have been considered and tried," unquote. It is my impression that in some countries, judge-ordered, non-binding arbitration is permissible for certain types of cases. Even within those areas where ADR is applicable, challenges to its jurisdiction may arise. Any party can appeal to the courts within 30 days of an arbitral tribunal's finding that it does have jurisdiction. So, for example, in Arch Reinsurance versus AK Holdings, it was held that the rights of a chargee under the National Land Code could not be taken away by a private arbitrable agreement. Raja Azlan Shah, as he then was, delivered an authoritative ruling in Syarikat Pemborong Pertanian and Perumahan versus Federal Land Development Authority on when a civil court is entitled to interfere with the award of an arbitrator. If knowingly a specific question of law has been referred to an arbitrator, then there should be finality to the arbitrator's decision, and no judicial interference should take place. But where an arbitrator's decision raises a material question of law, the court may interfere to give guidance if an error of law is evident. Ladies and gentlemen, arbitration was initially conceived as a tool to lighten the burden of the courts. It started as a regulatory system for settling commercial disputes pertaining to contracts and international commercial transactions. Arbitration mechanisms have since evolved from this original rule-based compliance to provide greater flexibility. This has enabled ADR to cope with the increasing complexity of the cases it deals with, many of which now involve multiple stakeholders and claims. As a result, the sector has grown to become an independent and much preferred method for dispute resolution. The type of disputes being referred to arbitration are also changing. These are no longer limited to contractual issues in construction contracts, cross-border transactions, trade and investment, and financial technology. They now encompass more complex, multilateral, non-contractual claims related to sovereignty and territory, expropriation of property, and international human rights. Dynamic regulatory frameworks are thus required in order to cater to the complex and evolving nature of both the contracts and the non-contractual claims that are now dealt with through ADR. The AIAC is well positioned to serve as a compass in charting through this new and challenging terrain. It is often said that the road to success is paved with obstacles. But remember also that a journey which is difficult to navigate is made far easier with a compass and a guiding hand. With the theme of this year's event, Compasses, the Odyssean course to modern ADR, befitting this notion, I encourage all participants to be open and to learn from your colleagues with their different areas of expertise. I wish all the presenters and participants a most fruitful 5-day journey. Let us hold fast to the mast as Odysseus did and not drift off course, and rather persevere in order to leave the conference with greatly enhanced knowledge and understanding. Thank you.
Menjunjung kasih Tuanku. Now, we humbly request Your Royal Highness to kindly remain on stage accompanied by the Right Honourable Tun Tengku Maimun and Yang Berbahagia Tan Sri Datuk Suryadi for the launch of our Asia ADR Week 2022.
We humbly invite Your Royal Highness to place the AIAC emblematic triangle on the compass in the count of 3, 2, 1. With that, we would like to thank Your Royal Highness for officiating the start of our illustrious voyage. Could we kindly have Your Royal Highness and the distinguished guests to remain on stage for a photograph? We now invite Yang Berbahagia Tan Sri to entreat His Royal Highness to his seat for the launch video of our Asia ADR Week 2022 with the theme Compasses, the Odyssean Course to Modern ADR. Ladies and gentlemen, behold our journey. On behalf of the AIAC, we would like to once again thank Your Royal Highness for joining us on this momentous occasion. This event would have not been made possible without Your Royal Highness's blessings. Ampun Tuanku beribu-ribu ampun, sembah patik mohon diampun. Mengumumkan keberangkatan Duli Yang Maha Mulia, Paduka Seri Sultan Perak Darul Rizwan diiringi div-div kenamaan.
Before we proceed to the first session of our Asia ADR Week 2022 with the topic Here Comes Sparta, the impact of armed conflicts on international arbitration, let us take a short 30 minutes networking break. We will resume the session at 11:30 a.m. There will be ushers to guide you to the Heritage Cafe at the lower ground floor for some light refreshments. We will see you shortly. Thank you.